Welcome to the Startup Dentist Podcast. I'm your host, Stephen Trutter. After over 800 plus successful dental startups, I'm here to share everything I know about starting a profitable and purposeful dental practice with you. Welcome back, Startup Dentist crew. It is super great to be back, and I have a special guest here today. If you are an associate looking to become a practice owner, and you're thinking about like how do I build value with patients? How do I connect truly with patients to grow a practice, to be highly successful, to make a difference in my community, even in some of the most saturated areas? Then check out my most recent episode. You definitely want to listen to this one. I interview one of our ideal practices clients. Her name is Dr. Arthi, and she is in, I'll tell you where she's at. She's in Manhattan, where everyone goes, you can't start up a practice in Manhattan. Man, has she ever. And not only has she killed it, but she's killed it one patient at a time. And she talked about truly connecting with that one person and how that one person just multiplies over time. So I think everybody's always thinking about like marketing gimmicks and marketing tactics, but this was about a system where she was truly immersing herself into a community, and community for her was even Manhattan, and to be able to build something special. So definitely check that out. Today, I have one of the biggest things that everybody, I feel like, a lot of dentists, they skimp on is legal representation. I think, and for business owners, it's like, oh, do I need an attorney? Yes, you do. And I have one of the greatest attorneys and one of the greatest people that I know in the entire industry. So we're going to talk about some of the legal blunders that can prevent you from becoming a practice owner and how to avoid those. So grab your notepad and let's make that dream practice of yours a living and breathing reality. All right, folks. One of my everyone talks about like their Mount Rushmore, so he's going to laugh at this, but I have a Mount Rushmore of people in the dental industry. He sits on the Mount Rushmore. Why? Because not only is he a great person, but he's a great dental specific attorney. He's one of the people that I would trust anybody, any doctor to consult with, that's going to give you honest advice, that's going to give you the guidance with decades of experience. So joining the podcast today is Mr. Rob Montgomery. He is also the host with Dr. Paul Goodman on the Dental Amigos podcast. So how you doing, my friend?
Doing well. Thanks for those kind words and introduction. I'm excited to talk to you, Stephen.
Yeah, everybody has probably seen Rob out there on different Facebook groups and everything. He has worked with a number of our clients, and I wanted to shed light on a number of things here today in terms from a legal perspective. So, Rob, well, if everybody hasn't heard of you, what do you do? What do you do? Just give everyone kind of this background other than we go skiing together and we have fun and things like that, and drink some really great wine, which we like to do that as well. So I guess we should have had wine today. Maybe we should have like
it's a little early in the day, but you could have made an exception. It would be business, Stephen.
Yes, it is. It's 1:23 on the East Coast, so we're good. Tell us about your firm and for everyone kind of give a context of what you and your firm have done, how you represent dentists, things like that in our community.
Sure. I've been practicing for 30 years. I've had the firm for 28. We're the law offices of Robert Montgomery, but we're better known from the URL of our website, which is yourdentallawyer.com. And it's funny the way that goes, because I somehow got like more credibility, Stephen, even though I've been practicing for 20 years doing this stuff. Like, oh, you've got that website. I'm like, well, yeah, but I kind of did some other stuff before I got that website.
That's right.
We represent dentists, some veterinarians, but really 90+% of our clients are dentists that we're helping with business and real estate transactions, employment matters. Most of our clients are people that are transitioning into practice ownership through startup, acquisition, and partnership. And we help people with associate agreement reviews as well. And then also most of our clients are first-time legal consumers. So they've made it this far in their profession where they haven't had to hire a lawyer for a real contract and a real matter. So we're used to managing people there are a lot of firsts, first practice, first acquisition, first deal, first time hiring a lawyer. And I've got a team of lawyers. It's great. I obviously this is going to sound like I'm biased, but I've got the best team and the best bench in the legal world, in the dental industry. There's lots of really experienced people that bring a lot of value to our clients, and we have a lot of fun doing what we're doing.
That's good. That's good. Well, you're much needed all the time, and I think that's one of the things where I think a lot of people get sidetracked, especially early on. So I think one of the things that you and I were together in Orlando at our Startup Practice Blueprint course just a couple months ago.
Yeah,
Actually,
great event.
yeah, 2 months ago. Yeah,
Always.
a month ago. Oh my gosh, time flies.
Yeah.
And we were talking about associate agreements, and I think one of the big blunders. So let's talk about some of the blunders that we both see, and it's kind of like those slap of the face things. Like you there's times where like I see you on Facebook groups, things like that, where people are asking questions. I just want to scream through the screen, like, this is all preventable. Like, stop.
Yeah.
And the associate agreement is like one of those things. And all the clients that we work with here at Ideal Practices, we always gather their associate agreements. We want to read what's inside of those, understand like what are we working with. And I think one of the big things, and even I've heard this from clients where they talk about employment agreements, is, oh, I didn't realize I could negotiate those. Sometimes they don't know what's in there. And so your associate agreement, like, listen, I know you're a D4, you're coming out of school, and you've borrowed a boatload of money to become a dentist. You borrowed $350,000, $400,000. What's $1,000 more to get your associate agreement right? Come on, folks. Like, this is going to prevent you from maybe starting a practice or buying a practice in a certain area. There could be strings attached to, it could be financial pitfalls that could like cost you tens of thousands of dollars because it's like, I didn't know that was in my agreement when I left. So like, Rob, what do we see here? Like, we see all walks, but like, what are some of the big things to look out for in terms of associate agreements?
Yeah, so a few things, but before I talk about some specifics, I mean, that's a great point, Steve. I think one thing that people should really realize is it's not, you don't hire a lawyer just because an agreement needs to be negotiated. You hire a lawyer to get advice, to get consulting, to get counsel on that agreement.
Yes.
Oftentimes, people do say like, oh, I didn't work with a lawyer because they said that they wouldn't make any changes. Like, no. That's the contract you have to hire a lawyer for.
Yes.
Because it's really, you're getting legal advice to help you understand what you're agreeing to. Now, and also sometimes, more often than not, thankfully, that also includes recommendations for changes to that agreement, but you need to know what you are signing yourself up for. And, I like to refer to that concept as contractual awareness when I speak to dental students and residents and young dentists that are considering entrepreneurial dentistry. Like, you have to know what's in that contract, know what provisions are in there, know what you can and can't do, and it's like the same thing of walking around a dark street at night. You know what's happening in your surroundings. You need to know what's in your agreement too. And a lot of times people will come to us and say, yeah, I didn't really read this. I didn't know what was in there. And that's just, as you said, there's just too much riding on this stuff.
Yeah. And I think corporate dentistry or even savvy employers, but I'll kind of point the bigger stick at corporate dentistry where they say, here, this is our boilerplate associate agreement. We don't negotiate. There's nothing to change in here. Whether or not you can or cannot change something is not the big thing. It's like you said, it's not the negotiation of the agreement. It's understanding what's in it and saying, is this the right place for me to go?
Exactly.
Because I may want to own a practice in this area. I want to acquire a practice. I want to start up my own practice, or things that could be just all these strings attached to that agreement. Beyond the compensation. And I get it. It's like everyone rushes out. I got a job. It's going to pay me well. I got student loan debt to pay off.
Right.
Whoa. Okay. Like, that's all great and all, but we've seen, non-compete agreements of, 20, 30, we've seen countywide, crazy agreements, termination elements and things like that. So I think it is the understanding of your agreement, and to spend $1,000, $1,500 or less in that range, folks, like, just you've already made the investment to become a dentist. And you're smart people. I'll just say it. Don't be dumb and then try to be cheap. And like, I'm not going to have anybody, review my associate agreement, because you can spend $1,000 today, but you could be spending tens of thousands of dollars later that could harm you, or things that are in there. So, all right, let's beat up on some associate agreements. Like, what are a couple things that are in there that they need to be looking out for? Now, again, everybody that's listening, these aren't just the only things that you look out for, but these are kind of things that kind of rise to the top of like things you need to really understand. And how, I'll say this, how savvy even some of the, Rob, today, like even the agreements where it doesn't spell out things and it's like, what does that mean then if I do leave or something like that?
Yeah, well, the ambiguity and uncertainty is not good for the dentist, right?
No.
That just means that there's a possible path to a lawsuit, and nobody wants to be a young associate with lots of debt, as you said, who's in litigation with a large practice owner or a large group. That's right. So you want things to be right. You want them to be clear. That's what we always tell people. Some things are more negotiable than others, but one thing that should always be right in an agreement is it should be clear. You should know what you can and can't do. And if it doesn't say that, then I think that's fair game to revise. So things, the first and foremost, restrictive covenants, covenants not to compete, and non-solicitation covenants. So covenants not to compete, meaning you can't work within a certain area for a certain period of time while you're employed and thereafter. Non-solicitation, meaning you can't solicit patients, referral sources, or employees. But even that becomes an interesting thing, because it may have a header of non-solicitation in that section, but it also may say that you can't hire people, or you can't treat people, or you can't advertise in a certain area. None of those things are necessarily solicitation, but they are things that could absolutely stymie your ability to practice and to own a practice in that area.
Yeah, absolutely. Now, some states don't have non-competes like California, but there's very few other than that. Right. So I think this, and everyone, with non-competes today, folks, like they're still enforceable. Right. No matter what you hear on the news, they were trying to get rid of them. They got struck down by a judge in Texas and says, yep, they're still enforceable. Right. So if you think that yours is not valid unless you're in a state that doesn't allow them, they are valid. And do you want to try to, here's the thing, it's like, do you want to try to see if they're enforceable? Like, I wouldn't. No, like, right. That you won't win. Even if you win, you lose.
That's the biggest, as you talked about, like Facebook groups and blogs and everything. That's what drives me nuts, Stephen, where I see somebody says, hey, I've got this 10-mile non-compete. And then all these people say, don't worry, it'll never be enforceable. No,
it's not enforceable. They'll never be able to enforce it. It's egregious.
Oh, it's in the worst of all.
You want to find out? You want to spend the legal cost to see if they'll defend it? Because they could, and they probably got deeper pockets than you, especially corporate dentistry and big employers. Totally. They've got much deeper pockets. They will defend it. Do you want to find out if they do? And even if you win, it's going to cost you time, mental capacity, and not to mention a lot of money to defend it.
Yeah. Well, here's what I say to people now. If somebody tells you, don't worry, it's not enforceable, ask that person for $100,000. Because that might be what it's going to cost you in legal fees to find out. And 12 months later, after you've quote unquote won and paid $100,000, the location that you like for your startup is no longer available. That's the practice that was for sale has been sold to somebody else. So you can't say like to a realtor, like, I love this location, it's within my non-compete, but some dentist on a Facebook group told me not to worry about it. So like, can you just put it on layaway for the next 12 months while I go litigate and spend $100,000 against this DSO that I used to work for? Just hold it for me. I'll be back. It's not
they love that. Yeah, agents love that. Yeah, sure. We'll sit on that for a while and see how that goes. No, the space is going to be gone. You're going to waste so much time. And I think in terms of like thinking about your associate agreement from before you step into the job, think about what your plans are over the next 2 to 5 years coming out of dental school. Pick an area where you work that is going to be far enough away from where you think, if you want to become a practice owner. If you're listening here, you want to become a practice owner. So if you're in my audience, you're listening to this podcast, you are a person that's saying, I do want to become a practice owner. Great. maybe you have to make a shift even today. Maybe you're in an area like, wow, I know I want to open up my practice here. I would switch employers. Get that clock started. If there is a non-compete, whether it's a year or 2 or 18 months, whatever that is. So even think before you sign the associate agreement, think about like the area. Is that somewhere where you want to be? You mentioned termination elements that are in the agreements as well, Rob.
Yeah.
Tell us like what's in those, and those have become kind of sneaky. I feel like these days.
It can. It's crazy because like there's two aspects of this. It's whether or not like the amount of time that you have to work, the term of the agreement, and then the notice that you have to give if you're going to terminate and leave.
Yep.
And so I went literally, Stephen, for 2 decades where I never saw a practice owner tell somebody that they have to work and that they can't leave. Okay. Shortly before COVID, as the proliferation of DSOs came in, all of a sudden I would see like clients were calling us saying, I've worked here. I signed a 2-year agreement. I've worked here for 8 months and there's not enough production. This is a startup office of the DSO. And they tell me I have to stay for 16 more months, and it's like, you look at the agreement, and sure enough, that's what it says. And there was a time, even when that stuff would be in an agreement, that an employer would never try to enforce it. However, I see demand letters, cease and desist letters from big law firms to associates that are trying to exit. So there are some DSOs, especially, sometimes private practice owners who have kind of borrowed agreements from these DSOs because they cloned them that say you have to work for a certain period of time. That's it, and you can't leave. That's a really bad thing at a lot of levels. One, circumstances may be that it's not what you thought it would be, or you may have other opportunities, especially entrepreneurial opportunities, that your hands are going to be tied. So that's a big thing. The other thing are termination, notice of termination. How much time do you have to give? 30, 60 days is kind of like the norm. Sometimes we'll see 120, 180. And, look, let's just start from a practical situation. Who wants to give their employer 180 days and then you have to work with them for 6 more months? Like, that's not cool.
That's a bad environment. That's a bad agreement.
Totally. But if you are looking to do a startup or acquire a practice, same thing as we're talking about the non-competes. This is about timing. Like if you have to give your employer 6 months notice, or you're going to be sued for not living up to your end of the bargain or giving sufficient notice, or they might say, if you don't give us enough notice, we're going to charge you $1,000 a day for each day short that you are on your notice period. Same thing. You may have an opportunity to buy a practice. You may have an opportunity to do a startup that's no longer going to be available there, or it's going to frustrate things. And as you said, Stephen, this is one of those things for no reason. This is a provision that you should know what it is going into it, and you should try to negotiate it.
Yeah, it's almost like forced labor. One of our clients, remember a few years ago up in Florida, it was like her agreement basically said, her name is Dr. Pauline. You remember this one? And it was basically like, hey, you have to stay until we replace you.
Yeah.
What?
Yeah.
No.
Yeah.
I remember a couple letters back and forth, and it was like, okay, yeah, you're out, because you're almost like, I hate to say it, like it's like forced labor at that point.
Oh, yeah.
Like you can't be forced to work for some place for an indefinite period of time with absolutely no, especially in this case, like they could have hired nobody to replace her.
Exactly.
And that was a reality, and that was the argument that got her out of that agreement to open her practice. I remember that vividly.
The other thing too, like there are some big national DSOs, and I'm not going to name names, that say you have to finish all of your ortho cases, for example, before you go. Which, we all know kind of what the cycle of treatment for an ortho case is. That means that you're going to be coming back on a fairly regular basis for a fairly long time.
Yeah.
And
2 years.
Also,
you got a 2-year tail on that.
Yeah.
Yeah. In a lot of cases. So I think a couple things to look out for is like in your social agreement, your termination, what's in there, non-compete, non-solicitation, understand what's in those agreements. And folks, like, get them reviewed so that you have a better understanding. There's nothing worse. And having been in partnerships myself and agreements, my thing about agreements is always, I want to make sure that both parties understand what's in this agreement. What does this mean to you? What does this mean to me? And more importantly, you as the associate dentist need to really understand, what does this agreement mean to me? And to have somebody review this is absolutely paramount to your future. And it could really prevent you from being a practice owner or having a really bad employment element, just a really bad employment period with an employer. So get them reviewed.
So true, Stephen. And let me say just overall, before we move off of associate agreements, but to the young dentists out there, realize that you've probably made it to this stage of your life and career without ever having what I would consider to be a serious contract. You've signed a lease for a Subaru, a rental agreement for an
apartment. Yeah.
That's all kind of like basic stuff. It's template. Yeah. There's laws that protect you, consumer protection laws and things. But when you get to these contracts, anything can be in them. So realize, a switch has been flipped. You are now in the grown-up contract world. These contracts are impactful and can define your profession and how and where you practice it. And they are super important. And there could be just about anything in there. And what's in there can impact you differently. That can impact your friend, colleague, classmate. Know that different mindset now. Now these things require your attention.
Yes. All right. Great segue to agreements, leases.
Right.
We're talking about leases we're talking about startups, or even if you have bought a practice, like leases. Now, this is a topic that you talk on stage for over an hour. So we'll kind of condense it here for our listening audience here today. Bad leases, crappy leases. They happen, folks. And you and I were talking offline. You said, let's talk about kind of the philosophical element of leases from kind of a 30,000 foot view, because leases can be 8 to 10 pages. They could be 75 pages. They're custom. Again, folks, just have proper representation of people that have negotiated leases. Leases are so one-sided. So when you sign an apartment, rental agreement, typically those favor the tenant in most cases. Yeah. Commercial leases are today 100% in the favor of the landlord or the owner of the space. All we're trying to do is, how do we shift that balance of power to a little bit more of something that is agreeable for two parties, not just completely one-sided, because leases are you going to get leases 100% in your favor? Never. But it's about what are the kind of the big points that are in there that could really create bad leases. And I'll say this, have an agent. I've talked about that before. Have proper representation into this. You talk about most important agreements. I'll say this. Yes, their associate agreement is probably a 1B. I'll put lease agreement. This can prevent you from selling a practice. This could cost you tens of thousands of dollars later, hundreds of thousands of dollars, like crappy, bad leases. So give us the philosophical Rob Montgomery. Give us the philosophy, I guess, of leases.
We look at this, especially most people are going to lease a space. And it's going to be a space that was not previously a dental office. So you're talking about building out what is referred to oftentimes as a shell or some version of that.
That's right.
So you're looking at an investment of close to $750,000 in that project.
Oh yeah.
To build out this space that you don't own. And notice I said investment.
Yes.
And an investment being that you are borrowing this money to invest in this project. You want to protect your investment, just like any investment. How do we do that? Again, you said these are very one-sided documents in favor of the landlord.
That's right.
I don't think it's an appropriate exercise to try to make them, quote unquote, even. You won't succeed. You'll spend lots of money and you'll probably kill the deal. Right. What you have to do is make sure that investment is protected, to make sure that there's nothing in the lease that could allow the landlord to move you to another part of the building or the shopping center.
That's right.
There's nothing in there that could lead to an accidental breach or default. So like operating hours in a retail center. If it says that you have to be open from 8 a.m. till 10 p.m, 7 days a week, that's not okay for a dental practice. That's okay for a coffee shop or a donut place, but not a dental practice. And if you're not open then you are in default of the lease, which means that the landlord could evict you, even though you have sunk all this money into the space, you could be
Crazy.
out. So these types of things, foot faults, we refer to them as, you don't want
That's
to have those. Other provisions that could lead to patients not being able to access the premises or you not being able to operate. There are those things.
Yeah.
Then we look at how do you protect an investment? Well, it's only an investment if someday you can sell it. So when it comes time to transition the practice, is there language in the lease that allows you to assign the lease, to pass it off to a purchaser of your practice? Because the number one deal killer that we see, because we do a lot of acquisitions as well, is an uncooperative landlord. So you want the landlord to have as little say in that process as possible.
We see that, and that's one of the things that we talk about, like Mike and Kyle on our Ideal Practice team, when we're talking about leases, whether it's a doctor that's doing a startup with us or is acquiring a practice and there's a lease that's involved. Everything, the lens that we look through, especially if we're all collaborating together, is this. The lens is, if I need to exit this space, I need to, or at the time that I want to sell my practice, what can I do? What can I not do as it relates to the landlord? So everything is kind of looking at this from a long range perspective of that. I think because there is the today part of the agreement, like, okay, what things are in there today? It's more of the tomorrow elements that you have to have that lens of, because tomorrow comes very, very quickly. You sign a 10-year lease. Wait a minute, that could happen. But even in that 10-year lease, all of a sudden you're 2 years in. I have to sell my practice. You have a medical condition. You have a family condition that forces you to sell your practice. Right. Okay, well, what are your rights at that point to be able to get out? And the biggest sticking point that we see with acquisitions, most people can kind of come together and say, yeah, I'm going to buy. Hey, Trutter is Dr. Trutter's going to buy Dr. Montgomery's practice. We've agreed in principle for me to buy your practice. Here's the problem: you have a crappy lease. Mm-hmm. That lease is actually preventing the deal from getting done. That's where the sticking point is. A lot of people can agree to buy the practice. It's like the lease gets to the end. All of a sudden, it's like, oh, hey, by the way, here's this thing. This is going to be a sticking point. I've seen it time and time again, especially today in this environment. I saw it in my banking days as well. Mm-hmm. Hey, we got a deal. This is looking good. Landlord is putting up a fight, and the landlord is actually possibly throwing a monkey wrench into it, where people are on these leases indefinitely. 2 or 3 other people can be on leases and things like that. So your liability. So you sell your practice, you should be out of that lease. And instead, some of these agreements basically say, you're still liable for me. And if I sell it to the next person, you're liable, I'm liable, they're liable. And it just becomes this never-ending story of liability for previous people that leased the space. It's insane.
I've seen it happen. I've seen 3 generations of practice.
You told me this. Yeah, you told me that.
And that same thing.
Yeah, you told me you saw 3 generations of doctors, folks.
Of owners.
Practice. Of owners. Mm-hmm. So 3 generations. You told me a story in Orlando. You said there was 3 generations of owners on a lease. That's absolutely avoidable. But think about like the liability. Like all of a sudden you get a call up. Hey, I sold the practice 10 years ago. The next thing you know, Mr. Smith, the landlord, goes, hey, so the young dentist just defaulted. I'm making my way down the line here. You're still liable for their debt. What are you talking about? Who wants that phone call?
One better, Stephen. It's not even a phone call. The sheriff shows up at your house and serves you with a lawsuit that you can sue for a 6-figure lawsuit because 2 generations later been paid. Yeah, surprise. But I think, as you said, though, and this is something that we see that's, I think, kind of bad advice that floats around out there. People say like, oh, you should have a termination provision in your lease. If something happens that you're disabled or you die, that you can just give the lease back. I'm like, well, that's not that might be a nice strategy in minimizing your liability to your landlord, but you still owe the bank $500,000. So like handing the keys back to the landlord, from my perspective, is not in the top 10 options when you become disabled, change of life circumstance, or you're sick or something that you need to sell. Because we have this conversation. This is a first conversation we have with all of our clients where we talk about these provisions. And, it sounds crazy, probably like, why is Rob talking about when I sell my practice? I haven't even opened yet. It's because these things come up. And unfortunately, we've seen them where people need to sell within a few years after they start up. And it wasn't their plan coming into it, but you need to have some sort of exit strategy and a meaningful one, not just to extract yourself from the lease, but you need to extract yourself from the lease, sell what you built to be able to repay your bank. And then that's when you've truly walked away.
Yeah, 100%. Yep. Really good guidance. So yeah, folks. So like leases are like, wow, it's a really deep conversation. But I think the most important part there to take away is understand what's in that lease, understand the long range elements. What happens when you sell your practice, not being able to relocate your practice, because listen, this is not like Rob, a law firm. Yeah, kind of a pain, but you can relocate. You could probably move your office in a weekend.
If I had to, yeah. It would be fun, but yeah, it could be done.
No, right.
Yeah, it could be done.
You can be done. A dental office.
I didn't put any of the plumbing in here or any of the electricity.
Right, exactly.
I didn't put any of the walls, right? It came with it, right? As they say in South Philadelphia.
I always say like that's a non-starter. That's like a non-negotiable of like if they say anything about like being able to relocate a dental practice, and they always have like crazy language in there, like things like with a like size space. Okay, well, like size space could lose you an operatory or two. Mm-hmm. That's like sized. What does that even mean? Yeah. No relocation. You can't happen because it takes months. You're making that investment. And I think that's an important element and takeaway from a philosophical big picture perspective is you're making an investment into the space. And this agreement is the most, probably the heaviest agreement that you talk about, like going adult. We're adulting now, in terms of agreements. Social agreement is like that first adult agreement. The second one is this lease that if you end up leasing space, that one has an impact on livelihood as well if it's not done right. So,
for sure.
Equity agreements. So we're going to kind of continue on agreements. Listen, I'm pretty raw on this. I hate buy-ins. I think they're awful. I think everyone for one doctor on a Facebook group that says, I did a buy-in a few years ago. It's been great. For every one of those, I'll give you probably 50 other stories of deals that never got through. They're completely one-sided. Mm-hmm. And I don't know if it's the fear of becoming a practice owner where it's like, I'm going to buy into this practice and I'm going to get this mentorship, or I'm going to feel like I'm going to get equity, or I'm going to have ownership. I'm going to say it 9 times out of 10, you're going to make a financial transaction. That's it. You're going to pay senior doctor or DSO or corporation some crazy dollar to buy into the practice, thinking that you're actually going to have ownership capabilities, and you're not. Because I think the biggest challenge I always see is if it's a senior doctor selling to a junior doctor, the senior doctor typically doesn't have anybody in their ear giving them advice that says, hey, when you sell the practice, you actually or sell, let's say 50%, for example, you are selling 50% of your practice to become 50% of our practice. They never think that it's never that way. It's still looked at as you bought into my practice, and therefore I'm still going to run the show, even though, but it's not their practice anymore. It's our practice. It's their practice. It's
and the team,
people's practice.
And sure, and the team's like, for 30 years, this has been my boss. Like they don't just come to work the next day after the buy-in closed and say, oh, okay, now I've got a new boss, and it's so reality is even if you're 50-50, a lot of times in those situations, you're 50-50 on paper, not in reality.
Yeah. And then what happens in a lot of those, especially with like DSOs that you were talking about, like equity agreements, where you get yourself in a position where you've bought into maybe DSO or corporate world.
Yeah.
How do you get out of those? And what are the strings attached because you bought in somehow? And banks are going to look at this differently. It's like, hey, you still owe this money over here, but then you want to do a startup or buy another practice. Like you have a lot of negative impact on those scenarios.
Yeah, they are the most predatory document / deal that we see in the dental world, hands down. By a factor of 5. Buy-ins are tricky, even with dentist to dentist buy-ins. Sometimes they're okay. The problems that we usually see are unrealistic expectations on the seller side and the buyer side, where they haven't done the cash flow. If somebody wants to sell the practice, they want to get the money for 50%, and and they want to make as much money as they were making before and they owned 100% and have as much say. That's not workable. That's a problem.
Reality.
That's a different set of problems. What
Yes.
I see in the DSO minority buy-in to one location, we refer to those as, there's partnerships, and then that's called a partnerships, and it's spelled PARNASHIPPZZZ. It sounds kind of like a partnership, but it's not, and it's nothing but a retention strategy. And because
totally. Yeah. It's like golden handcuffs.
You can't
golden
go.
handcuffs.
You can't. You
That's
can have a bad non-compete. You may be prohibited from working within 50 miles of any of their locations around the country. You can't get your money back, or you sell their interest and then they pay you back over 5 years. But when you sell your interest, you owe the bank 100% that day. So you can't pay the bank off because you're not getting paid for it. So you can't leave. These are all strategies that we see in there. And the other reality is, and I'm sympathetic to this, that these are documented as in a really confusing way. They're documented oftentimes the same way that people that are selling their practice to a DSO for $20 million are documented, except, the amount of the transaction doesn't justify the cost to do this right. So right. People look and they're like, will send us literally, Stephen, 15 agreements that, probably are several hundred pages, and for this $250,000 buy-in, and there's nothing in there that's intuitive as to what the deal is. And they're not at all transparent. They've got all this bad stuff in there. So it's like, it becomes really hard and expensive to figure out what you're doing. However, you have to,
yes.
And a lot of times with those deals, people will send those to us, and our normal workflow is, hey, we're going to review this document. We're going to propose changes. We'll jump into that asset purchase agreement or into that lease or that employment agreement, start doing a thing. With these, they're like, okay, give us about 4 hours to review all this. And then we're going to have a call and we're going to tell you what's in there. And after that conversation, I don't think you're going to want to spend any more money or time on this because, as you said, Stephen, that's not ownership. If you think like I want to be a practice owner, that ain't it. And it's not even a partnership. It's a partnership.
I think I would sum this up in saying, like, everyone, like, don't just chase something to call yourself an owner because you're afraid of doing it yourself. I think that's what this is. I understand it. Startups are risky. Buying a practice, going out on your own is risky. But folks, like, there are so many great resources out there to guide you to become highly successful. Don't just like trip into and say, this gives me ownership and think that like this is a great like stepping stone in becoming a practice owner, because it could be a stepping stone into a murky lake of like crap that's there. And so don't just like chase don't chase the idea of ownership and find something that says I get an ownership stake and not realize that you're just your ownership on paper. You're parked there. You mentioned one of the things, this kind of ties back to our first topic. We were talking about associate agreements. I don't know if you heard online recently, Rob. So flag football is now a new sport in the Olympics. Interesting how that's going to pan out. Like, is there like I don't know if there's a flag football league out there. I think there is, but it'll be interesting to see, if Jalen Hurts from the Eagles or somebody like that's going to be tossing things and running around on Olympic.
Jalen Hurts better not be playing flag football in the next season. That's all I'm going to say.
I know. Hey, everybody. Rob's from Philly, by the way. Rob's
that guy better
not diehard.
Yeah.
I don't think Lurie's going to allow him to do that. I bring up the Olympics because people talk about the Olympic rings, like what's the, the symbol, the little, everyone knows the Olympic ring emblem. This is what you're sometimes with non-competes. If you work in a place like a DSO or even a multi-location practice, is you could find yourself, well, my non-compete I thought was just the practice that I work. Well, depends on where you're working. And so if you look at the Olympic rings, it's like you could have an area that's like this, we call it the Olympic ring philosophy, which is your non-compete could be the Olympic rings of all these other areas, because wait a minute, the DSO says I'm not permitted to work here at the place here. And you mentioned the other locations that are in just geographic area. So now your 3 to 5 mile non-compete just went to 50 miles because they have 5 other locations. So imagine the Olympic rings or bigger.
Let me stop you there, because when you look at the rings, you're talking about pi r squared, right? So that's easy math for me, So it's like that's 315 or so miles, square miles in each one of those. If you have a 10-mile radius,
true,
right? So now you have 7 locations. That's over 2,000 square miles that you can't practice.
I never thought on the Start Up Dennis podcast we'd be doing pi r squared here. I mean, geez, man, you've lifted this podcast to a whole nother level here. Rob.
I memorized
pi
that.
r squared.
I memorized that before I came on, Steve.
Okay,
I did the math already. But here's the catch with this too. Let's just go back to those equity agreements. A lot of times, and this is really more common and more often than not, you may have a non-compete in your employment agreement, and maybe it's something reasonable that you agree that they say can't work within 5 miles of that location. Okay, that could be reasonable in most places of the country. But then that equity agreement, the operating agreement, may have a non-compete that says that you can't work in any state in which the DSO owns or manages a practice. That's not cool, and so, you may not even realize what you signed yourself up for, and
That's right.
It's Olympic rings on steroids.
That's right.
You start looking at a good chunk of the North American continent that you're not allowed to practice dentistry in. And, that's why you have to know what you're signing.
That's right. That's right. Love it. I'm going to close out here with this, which is we talked about, I'll just say this, boilerplate agreements, cheap representation. And I'll say this. It's funny. I hope if this dentist is listening today, I'm not going to pick on you. Well, I am, but I don't know your name. You're anonymous. Somebody on one of the Facebook groups this morning, literally as before I got jumped into the podcast here. So someone was asking, hey, I'm buying this practice. I've been working in for whatever period of time. And I need to figure out, can I negotiate the price with the seller? And then there's like this whole diatribe of like other things that they're saying. It's like, hey, and they're not going to sell the building, but I need to look at the lease. And, they're going to stay on because he's been there for decades. And, what's the employment agreement? Can anyone give me any samples? Why samples of what? Like, folks, like there isn't. Yes, you could get samples of agreements, but they're not going to be personalized to you. So I couldn't believe it's like, again, like maybe it's the avoidance of like paying for good representation or the avoidance of paying for good advice. Kind of back to like this cheap thing. You're making one of the biggest life decisions, personal, professional life decisions, and you're going on a Facebook group asking for samples of things that could literally haunt you. Like to even say, it's like, oh, how long is the doctor going to stay on board? Well, I don't know. Like he's been here for decades. He's going to be great. I'm going to pay him. And then he said, he wants to be paid 35% of production. This is a 2-doctor practice. Is it a 1? Like all these, and again, I don't want to beat up on this person, but if this person is listening, I'm just going to say my response, and I did respond on this Facebook group, was samples are irrelevant. Mm-hmm. Boilerplate agreements are irrelevant. It means absolutely nothing. So I know your take on this, Rob, but like you see it, and I always say avoid those elements that are there.
Yeah. I mean, it's for us, like the actual agreements are just like, that's like the basic framework for what we're doing with our clients. Yeah, I think
that's right.
That's just somebody that doesn't understand what it's like to work with a lawyer, a CPA, and a consultant in a meaningful way. They're so far away from what they should be thinking.
Yeah, I can DIY this. Yeah, like, hey, I can figure this thing out. I can kind of maneuver through this.
Yeah, I mean, sure, you can get documents. You can put the names and the numbers in. Sure. You can sign them. You can get to closing. Like, that's just this ministerial aspect of that, which is, frankly, in the context of what we do most of the time, is like a commodity of what we do. It's all the other stuff where you're talking to somebody, a consultant, a lawyer, a CPA, who's guiding you through this specific situation and making constructive suggestions and giving you good advice to help put you in the right place at the right time.
Like the value of one-on-one. The value of one-on-one, folks.
Yeah. And like, there's no, and sometimes people say, like, tell us the way to do this. Like, we just met. Like, I don't even know what you want. Like, I don't know you. I don't know your vision. I don't know anything about this practice. There's not some universal way to do anything, just like there's not a universal document. Like, to me, when I see that there are people out there that say, oh, we're a startup consultant, here's the way that all startups should work. Like, that's crazy, or tell me, the way that we should always document and represent people in a legal transaction to buy a practice. There's no such thing. It's like what we get involved in, where our value comes, is helping people through the process to avoid problems, make them understand what it is that they're doing, and try to help them achieve their goals. The actual what's on the paper, that should be a fairly basic thing in the grand scheme of the project, but it's all this other stuff. And anybody that says that I can do it and I'm going to do it the same way for 100 people, that's not somebody you should hire, because that's not helping you. That's helping them scale their business. The business model that's like, what's good for one is good for all is not good for anybody. Yeah.
And I'd say this, like, you can't, what did you say? You can't make a bad deal good.
Yeah. I mean, that's it. I mean, lawyers, and that's it. And that's the importance really of the deal, the cash flow, knowing the economics of what you do. And cash flow is so key, Stephen. When somebody has a conversation with us, early conversation, buying a practice, or they're doing a partnership or some sort of transaction, we're like, the first thing is, who is your CPA? You don't have one? Okay. You need to work with one. Here's what they need to do. They don't need to, they can look at the valuation, but I'm not that interested in the valuation. I don't want to hear that it's $100,000 too much or $50,000 too low. I want to know, after you borrow the money, pay the bank, make money being a dentist, how much money are you going to make? What is the projected cash flow? Because that's what matters. Because we can do, as lawyers, the greatest bit of legal work ever on a deal. We can't make a bad deal good.
That's right. Plain and simple. I love it. I love it. Cool. Rob, great to see you as always.
Same here,
Thank you for joining here. Where can everybody find you?
I'm hiding on social media and everything. No, that's a joke. We're out there.
That's right.
Our website is yourdentallawyer.com. Facebook page, Your Dental Lawyer as well. We're in the Dental Nachos gang from time to time. And as Stephen said, I do a podcast with Dr. Paul Goodman, Dr. Nacho, called the Dental Amigos. And so, the easiest way to reach us is probably through the website. But, we're out there speaking to groups and get involved with ideal practices, and always speak at your seminars, which are awesome. I look forward to the next one too.
Coming up, we're getting ready we're in the midst of launching. It's going to be coming up in October here really soon. So, Rob, thanks for being here. And for those, you want to connect with people like Rob and experts. He mentioned our course, Startup Practice Blueprint. You want to be immersed into the startup stages. You want to be immersed with one-on-one expert guidance from people like Rob. Then come to our next Startup Practice Blueprint course. You can find that. You can register at startuppracticeblueprint.com. It's deep, it's intense of 2 days, really getting you ready for not only the elements of a startup, but the mindset of getting you prepared and giving you meaningful steps forward for you to become a successful practice owner. All right, folks, that's a wrap on the legal blunders and how to avoid those. Don't forget to check the show notes for any and all links and resources that we talked about today. As we wrap up this episode, take a moment to picture yourself a year from now. Are you still in your associateship, or are you rocking it at your own dental practice, creating beautiful smiles and making a real difference? If that's the dream, it's time to chase it. Before we split, make sure to hit subscribe, drop a review, and give us your rating. It helps us keep bringing you the good stuff that you're into. Until we meet again, keep taking that next step towards your future practice. Here's to investing in your dreams and making them a reality.